Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Mary Margaret Bush, Napa Legal's Executive Director.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we have an exciting special episode where we're joined by our two guests, Tyler Martinez, who's Senior Attorney at the National Taxpayers Union Foundation, and Brian Hawkins, the Senior Director of External Affairs at the People United for Privacy Foundation.
We recently discussed the Corporate Transparency Act on the Napa Legal Podcast. There's been a lot of excitement around this, with all three branches of government getting involved. The CTA has been the subject of media reporting, litigation, and executive action over the last few months, and we're so excited to have some esteemed guests on the podcast to unwind the confusion here. Tyler and Brian recently wrote an article at the Washington Times on the CTA, and they're here to discuss the statute itself, the current status of the law and its implementation, as well as the problems the law presents and some of the underlying principles at play here for nonprofit organizations. Tyler and Brian, thank you so much for being here with us.
Thank you for
Thank
having
you for
us.
having us.
Let's dive right in. I think before we get to some of the problems and issues with the CTA, particularly as it relates to nonprofit organizations, let's just start with a brief overview of what the Corporate Transparency Act actually is. So, for all these questions, you guys can take it in whatever order you'd like, but let's just start with what's the purpose of the CTA and what are the requirements of complying with it for those who are affected?
I'll take this one. I'll take the softball ones. You get the hard ones, Tyler. The Corporate Transparency Act. It's legislation that basically requires reporting companies, and of course, that's a whole definition within itself, but usually limited liability companies, so LLCs, requires LLCs to disclose who their beneficial owners are, and a beneficial owner is described as a person who has a substantive amount of control over the LLC, and it does this through a disclosure scheme where anyone who is defined as a beneficial owner has to submit their personal information to include like their passport and some type of picture ID to FinCEN, Financial Crimes Enforcement Network, which is an agency within the Department of Treasury. And FinCEN is tasked with creating this massive database of beneficial owners of LLCs. The purpose of this law was to tamp down on financing for terrorist organizations, money laundering, and other type of illicit activities. It was passed through the NDAA, the National Defense Authorization Act, in 2020. Was one of the last bills during the first Trump admin. Ironically, which we can get into later, but President Trump actually vetoed the NDAA, but then Congress overrode his veto and passed it to include the, of course, Corporate Transparency Act that this bill was in. So yeah, so big picture wise, all LLCs, and there's a few exempt entities to include nonprofits, which we'll discuss more later. But all LLCs basically need to disclose to the federal government who their beneficial owners are, so the federal government can track all types of financial activities. But it's meant to combat money laundering type of stuff. Tyler, do you want to fill in anything I might have missed there?
Sure. I'll just add that it's not just LLCs, it's corporate entities, it's HOAs. So like your local HOA is being treated as if it's some sort of, terrorist crime network. And so, these volunteers, even for your local neighborhood, as much as people tend to not like HOAs, their personal information is being recorded at the federal level for the mere, problem of, trying to make sure that the hedges are trimmed properly or whatever. So it's a very expansive rule. If you're at all familiar with how this stuff works at the state level, some states require this level of detail, some states don't. Some states, it's typically a state issue. It's always been a state issue for registration of corporations, but now the federal government has gotten its hands in the mix and wants as much data on Americans as possible.
And if I could just have you clarify one thing quickly, because Brian, you mentioned this is reporting information for beneficial owners of these entities. We'll talk about this, but most nonprofits should be exempt, although that's a separate question. But nonprofit organizations don't have owners in the colloquial sense of that, right? But the way I understand it, beneficial owners will include certain leaders of nonprofit organizations as well, even if they're not technically an owner. Is that right?
Correct. So the way so nonprofits are exempt from this law. They're not considered reporting companies for the reasons you just mentioned. But this is still relevant to nonprofit organizations because, as imagine your network and your members know, a lot of philanthropists like to use LLCs for their philanthropic giving. There's lots of good reasons for it, lots of privacy, more flexibility. Um, so if you are a nonprofit organization and you're receiving funding from an LLC, that LLC is going to have their beneficial owners disclosed to the federal government. So and another key piece with the LLC, with the reporting, it's called BOI reports, beneficial ownership information. One of the problems with the BOI reports that FinCEN holds in this massive database is that basically any government entity can have access to that information. Now they did some rulemaking, there's some protections around it, but like any law enforcement agency from across the federal government could go into FinCEN and say, hey, we think we need this information about this LLC. Can you give us the report on beneficial owners and stuff like that? So it's really scary. Then there's hacking concerns. We've seen leakers from the federal government. With IRS leaking tax information about the National Organization for Marriage. We've seen federal contractors from the IRS leaking the tax returns of Donald Trump and Elon Musk. So even though this information is not disclosed publicly, you have this massive database of personal information that any leaker and hacker can tap into. So all that to say, to get back to my original point with the nonprofits is, even though nonprofits are exempt, it's still a very sensitive intrusion of information that can impact how nonprofits operate and the people who give to nonprofits.
That's really helpful, Brian. So, while nonprofits are exempt, they're definitely not unaffected by what the
Sure.
Corporate Transparency Act purports to do. Um, can you tell us a little bit about the family history of the Corporate Transparency Act? I know it was passed back in 2020, and right out of the gate, pretty much all three branches of government got involved with everything from injunctions to Supreme Court to back and forth with the executive changes and the administrative agency rulemakings. Can you talk a little bit about what's been the activity around the Corporate Transparency Act and the implementing regulations, as well as the litigation challenging the act and the regulations?
Sure, I'll take this one. There's a lot that's gone on.
Yeah.
When it was passed, as Brian said, it was passed through, quite frankly, the military spending bill, right? Like it should be about enough warplanes and ships and stuff to defend America. But this was added as a budget rider by somebody who particularly cares about collecting as much data on Americans' activities as possible. And so this has been a real problem. What the issue is that no one really seems to like it. So as Brian indicated, that the president at the time for his first administration, President Trump vetoed it. His veto was overridden because the military needs to be funded, and so it still passed. But beyond that, no one really likes to actually make this happen. Ever since then, there's been legislative proposals trying to fix it. The latest one, the one that's gotten the furthest, is current HR 736, which is a House bill that passed unanimously, so bipartisan support, to extend the deadline for compliance till next year, to January next year. That's currently sitting at the Senate, but like there's been multiple attempts to try and claw this back since it's passed in 2020. As far as litigation goes, oh man, there's so many cases all across the country going on. It's sort of a mess. I'll highlight the top four cases that are kind of what's going on. There are two cases out of Texas that have been the ones that you probably seen in the news the most. The one that went all the way to the Supreme Court on emergency procedures was Texas Top Cop Shop, which is literally a business that sells law enforcement equipment and guns and those sorts of things. But that case went all the way up to the U.S. Supreme Court. There were injunctions. Then the appellate court stayed the injunctions, and then there was an application for staying the stay, and it was all complicated, and it's gone up and down um, all around. So those cases have made it the most all the way up to the U.S. Supreme Court, where the U.S. Supreme Court said stopped the or stayed the injunction, which means the Corporate Transparency Act's requirements were back into effect. But there's other cases as well. National Small Business United have filed a case out of Alabama. It's already at the 11th Circuit as well. Um, and then there's in Eastern District of Virginia, there's the Community Associations Institute. In other words, the HOA groups that I mentioned earlier have also filed suit. There's other suits all across the country, but these are the ones that are bouncing around. So we have cases out of the Fifth Circuit, which is Texas, Louisiana, and Mississippi. We have one out of the 11th Circuit, which is the other part of the southeastern United States, and then now one that's working through the Fourth Circuit. It's a mess. I'm involved in some of these cases as amicus, as counsel for the National Taxpayers Union Foundation, and I get all kinds of updates on the court docket all the time. As oh, there's this new development. Here's a letter telling us about the new development, and so it's been a real mess. Everyone's trying to figure out how to work with this. Everyone sort of understands that this is a big deal, and so the courts are struggling with this, but there hasn't been any final resolution yet.
The legal challenges are fascinating, and I think we'll get back to them. But I want to turn at least briefly here to a practical question. So I want to talk a little bit about what the main practical or policy concerns are about the Corporate Transparency Act, right? So Brian, I know there was a little bit of an interaction on social media. You posted your article, and I think I was the only like positive comment on the pause at the time of the Corporate Transparency Act. And then you have a bunch of people defending it, saying, oh, this is just a way to prevent money launderers from creating small businesses and using them to anonymously commit crimes. And why are you against, stopping money laundering? So I guess I'll just frame it that way. What's the problem practically with this law? If this is not just an effort to stop money launderers from using small anonymous entities, what is it? What's the issue here?
Quick note before I answer that on the LinkedIn post. For some reason, the LinkedIn algorithm caught that post and it just spread like wildfire. No one cares. Like my posts usually fly under the radar, but that one got picked up somehow. But so the key problem with this law is exactly I touched on it a little bit earlier, just the massive trove of information that it empowers the government to have about private individuals. And it's and I'll touch on this a little bit later on, but it's comparable to the AFPF v. Bonta Supreme Court case, Americans for Prosperity Foundation v. Bonta, where Americans for Prosperity Foundation sued because the California Attorney General, who was Kamala Harris at the time, tried to extract their Schedule B 990 forms, and it went all the way up to the Supreme Court, and the Supreme Court ultimately determined that that there is a right to association in the First Amendment, and that the government cannot just have a mass dragnet collection of private information. They can have targeted access to information, or you get a warrant, or you have some type of probable cause, and they have a need to investigate, and then they'll say, okay, we need your 990 for that. So the Corporate Transparency Act flies in the face of this concept that the right to association, because it essentially says, like Tyler mentioned before, that, oh, we're trying to find terrorists and illicit money laundering. So rather than targeting specific terrorists or people who are engaged in money laundering, we're going to assume that all LLCs, all reporting companies are engaged in this illicit activity, and you must submit this information in order to make our jobs easier. So that's the key problem of the law, is just it exposes everyone's personal information in order for the government to try to do their job in capturing a few different people. I'll pause there, but at some point soon it might be relevant to mention some of the recent rulemaking that has occurred that affects the statute and the litigation. But I'll defer to your judgment on when we can talk about that.
I would like to add, it's really important to remember that if you find out where people are spending their money or where they're associating, you find out a lot about them. You find out what churches they go to. You find out what clubs they're associated with. You find out, who they are as people pretty quickly by tracking money. And so this idea that every corporation or everybody who's just existing in society needs to report to the government, particularly to the federal government, to just be warehoused just in case, is a very dangerous tool. That's beyond the issues of hacking or illegal disclosures like the Little John case, where Little John took a lot of private information, including some nonprofits, Schedule B donor list, and that sort of thing. Um, if it's warehoused, it's accessible by somebody, and so we really want to be careful about in violating the right to privately associate. And here, the federal government just doesn't have enough of an issue there. It has issues for it can support an idea for targeted law enforcement activity, sure, but not for everybody everywhere reporting to the federal government.
Yeah, you both make a great point on that, that it's a problem when anybody in the federal government has access to this much sensitive information, but especially the way the CTA is structured, so many people and so many departments and agencies have access to this information that the problem's pretty clear to me. So I think Mary Margaret, you had a question about how this can maybe be salvaged.
Yes, yes. Brian, you alluded to all the rulemakings that have been taking place. So, for the benefit of our listeners, if you're not already familiar, well, we have the CTA, which is the law passed by Congress. And then there are all the implementing regulations that come from the Treasury, which is, of course, part of the executive branch. So, on March 21st, the FinCEN issued a new regulation, a new interim final rule related to the CTA. So I have a two-part question. Maybe we can start with you, Tyler, and then Brian, you can kind of wrap it up. But where do things stand now after this March 21st rule? And the second part of the question is, did the new rule address any of your concerns, and if so, why? And do you have any remaining concerns? Because obviously the back and forth with the regulations can provide some temporary relief, but the CTA as written is still on the books. So just to recap the question, where do things stand, and what are your concerns at this point?
Or where they stand right now under the regulatory proposals is that the Department of Treasury keeps trying to shrink down how much information is collected. Now they want it to only be people from foreign sources now. Okay, that's helpful. They're delaying the enforcement provisions because before it was, if you hadn't filed by January 1st, then you were going to be in a lot of trouble. There would be fines and those sorts of things. They keep delaying all the enforcement procedures on those sorts of things. And Brian has more details on that. But what you see is a lot of regulatory work on this. There's some executive orders as well. These are all helpful, but they're not permanent. You get a different administration with different priorities. Maybe something happens in the news and the government decides it wants this information after all. And all of a sudden the regulations can change. The executive order can be signed. It was signed into existence in a few minutes. It can be signed out of existence in a few minutes. So the fundamental problem is the statute itself. The statute just shouldn't be there. It's too much power for Congress to assert over what should be a state's right, a state's prerogative, and it certainly doesn't need to be collected. But like I said earlier, what you tend to see is it passed, and no one wants to do anything with it. Everyone wants to try and narrow it. Everyone is trying to fix it. These are band-aids, but the ultimate problem is the statute itself.
And to clarify, so the March 21st rule from FinCEN, it narrowed the scope of the reporting requirements to exclusively foreign companies and foreign nationals. So US-based companies do not have to report under the CTA under this new rule. It still has to go through the rulemaking process according to the APA. So it'll go through public comment period before they issue a final rule. I mean, but also to build upon what Tyler said, I mean, yeah, the law still exists, and Congress is already kind of intervening. I think White House and Grassley sent a letter to the Department of Treasury saying, like, hey, this isn't entirely what Congress intended with this law. So we're watching. Um, and then and it's mixed because the letter of the law does provide the regulatory state, the department, some room to grant exemptions on how the law is enforced. The spirit of the law says that yeah, it should be a broader scope of reporting companies. So at the end of the day, I think Tyler is spot on that as long as this statute is out there, I mean it's a powder keg, and I mean, so we're fortunate for the rulemaking that's going to narrow the scope. But as long as it's still out there, there's another future admin that could come and just reverse everything, and that's going to be the core problem.
What I'm hearing from you both is that when there's a bad statute on the books, the proper remedy is not to just regulate and narrow it to death, but to actually repeal the statute. So if that's what I've heard, then we're 100% on board with you there. Okay, I want to turn toward nonprofit issues in particular, and we'll get to. I know Brian, you mentioned this, the use of small entities as vehicles for philanthropic giving, and we're going to focus on that. But I want to point out a threshold question, and if you have comments, fine. But even if not, I just think it's worth putting out there. We did some research on this when the CTA first came up about a year ago. I think we started when it was coming into effect. So we started looking at this, and there is a broad exemption, right? 501c3s are exempt from the Corporate Transparency Act, from the reporting requirements. But it is not clear from the language of the CTA, at least not to us at Napa Legal, and I think not to a lot of people because there was a lot of talk about this, whether the nonprofit has to actually have its IRS determination letter in hand to be an exempt entity under the CTA. And that's a problem because anybody who knows how nonprofit formation works knows that the chances are, so when you form the organization, right, the clock starts ticking, you have 90 days to either be exempt or to report. The chances that you're going to have a determination letter from the IRS in hand within 90 days of formation and submitting that are, I'd say, slim to none, right? So the way I read it, it's not clear whether nonprofits are exempt before they get the determination letter, and that's a huge problem, right? Because if nonprofit, the people who would be beneficial owners are not covered by the exemption from the beginning, but they're relying on anonymity, right? Then this is an issue because you have, a chairman of the board or one of the incorporators of a nonprofit may very well have to make the initial report. And to both of your points, once the information's there, it's there, right? If you have to make your initial report, but then you get the exemption letter, and so now you don't have to report any further. But yeah, now it's too late. Now the federal government has all the beneficial owner information, and it's just there. And the way I read it, most or all 501c3s that are new, once the CTA is in effect, are going to have to report. Is that right? Do either of you have thoughts on this?
I agree. It's not clear. And I think you're going to have a lot of people worried about it. When you're setting up nonprofits, people want to comply with the law, but they also tend to be very, very cautious because everyone's afraid of the IRS. That's my day job. My day job is helping out a lot of organizations that are worried about the IRS. The IRS has all kinds of power and tools, and so but it also moves very slowly, as you mentioned. It takes forever to get a determination letter. Once you have it in hand, it's lovely, but until then, and for tax purposes, you can still say you're exempt while you're waiting for the determination letter. But the CTA is not clear. I think if you had a very aggressive Department of the Treasury or Department of Justice deciding to just go after this, you could have them go after a lot of brand new nonprofits. You certainly saw that with the IRS a long time ago with the lowest learner issues and exempt organizations. When the IRS decided to go after groups in that determination process, they said, "Well, I don't know. I think you're really more political. I don't think you're really a charity." Because you talk about things that are hot button issues or those sorts of things. And it was a real scandal. And handing this to yet another set of regulators is going to be just as much of a problem.
And
That's
it brings up a concern. May Margaret, you asked earlier, like, what are some fixes that should be proposed, and I think that would be one of them, clearly, to make it more clear that determination letters should count, or pending determination letters should count as exempt. But I speculating here by I assume that the new rulemaking that narrowed the scope of the law is just going to delay any interest in Congress in wanting to kind of do these type of reforms. So once again, this law, the rulemaking is welcome. It's a very good rule. But now, when the law is still on the books, and any fixes that could be done through Congress, just probably won't be any appetite for it, unfortunately.
I would like to add one other thing. When you talk about even narrowing the scope to you know foreign based activity, whether it's a foreign corporation or a uh, foreigners who are beneficial owners, remember that like that can hit missionaries, right? Like that can just you don't know who's a foreign national just by the information. You just know they have a foreign address. So just because somebody has a foreign address doesn't mean that they're not a U.S. citizen or whatever, but they're starting to be caught up in the system, all for the sake of worrying about foreign influence or whatever. But there's a lot of people, a lot of Americans who are living abroad for a lot of reasons, especially in the nonprofit sector, whether that's for religious based organizations or secular based organizations that are just doing humanitarian aid or whatever. There's a lot of charities that do a lot of work, and that means they get their mail in a foreign country. That doesn't mean that there's some sort of nefarious activity going on, though.
Yeah, Tyler, I think your allusion to the Lois Lerner situation, I think, is a very. I hope it's not prescient, but it's very relevant to bring that up, and I think this poses so many of the same issues, and I think. We'll talk about this a little bit at the end, but the issue of the innocent sort of being looped in with the guilty in order to you bring everybody in order to find a few wrongdoers, and like we've talked about, the process is the punishment with this type of litigation or these types of regulations, excuse me. Um, I want to circle back to the question of litigation. You mentioned, Tyler, there's been a deluge of cases challenging the CTA, challenging the regulations. As Brian mentioned, the dust hasn't settled on the regulations yet at this point. But I want to look at the litigation. From the perspective of a nonprofit that's compliance minded, where do things stand now? Does any of the litigation address the core issues? Like Tyler, you mentioned the law is the problem. The regulations are kind of a superficial thing. Are there any cases that challenge the law itself that might get a bit of a foothold for privacy and for our first freedoms? And will the change in rules negatively affect the course of that litigation or reduce the chance of a good outcome?
I don't know if to answer the second part of that question first. I don't know if these reforms will work because if to be a little wonky, there's been a lot of changes in administrative law recently from the Supreme Court. The Supreme Court has said we're not going to just rely on what agencies say. We're going to actually look at the statute and see if that what the best reading is. That of course was Loper Bright was a recent major case on this. Um, but so we don't know that a regulatory band-aid will just be automatically taken by courts. So I don't know if that will impact it or not. There are certainly people making the First Amendment, the right to privately associate arguments all throughout on these cases, even if the organizations themselves aren't. So, for example, National Small Business United is a trade group basically that represents a lot of small businesses. That's in their name. Look at that. But I wrote a brief that talked about associational privacy and why that's so important. And I talked about the First Amendment. So there's those arguments are getting before the courts, but and so I think they will at least consider them, but they're not necessarily brought by each individual corporation because nonprofits are at least theoretically exempt. But there are groups like ours. We at National Taxpayers Union Foundation care deeply about donor privacy, care about financial privacy generally, but we work a lot on donor privacy uh, all over the country, and so we wanted to bring our expertise to bear on that. Um, I think the courts will need to consider it very carefully, and I think ultimately the U.S. Supreme Court will have to hear one of these cases and will consider it. I will certainly be ready to file and talk about the First Amendment as soon as the opportunity is there.
I'll add a couple of the plaintiffs have mentioned AFPF and the right to association privately in their arguments. National Small Business Association did, but in the judge that heard the case, he didn't rule on it. This was a year ago. This was the first lawsuit that actually filed an injunction against the law. But the judge actually didn't rule on it. He filed the injunction under the Commerce Clause, saying that the law violated the Commerce Clause. He didn't touch the First Amendment claim. Texas Cop Shop also made a First Amendment claim, citing AFPF v. Bondi, basically asking, does the right to associate extend to corporations? Because remember, like all the case law on donor privacy and the right to associate, AFPF v. Bonta, NAACP v. Alabama, those are all nonprofits. So Texas Cop Shop actually fairly explicitly asked, does it apply to corporations? And once again, I don't think a judge has addressed those merits yet. But so between that and MTU and other partners, constantly bringing up that First Amendment claim, hopefully one of these judges will have to say, we'll have to rule on those merits.
Now, I want to hone in on something that, Brian, you brought this up earlier, but I think it's worth focusing on, especially because most of our listeners either work for or with nonprofit organizations. So in the article that you published in the Washington Times, which was excellent, by the way, anybody listening who wants to learn more about this, especially from the lens of how this affects nonprofits, would do well to take a look. So this is in the Washington Times on March 4th, Nonprofit Concerns with the Corporate Transparency Act. So you point to the fact that philanthropists use small business entity structures for charitable giving. Can you, either of you, both of you, explain a little bit more about that process and how philanthropists use that, and then about how the CTA reporting requirements could hurt this process and ultimately hurt nonprofits who rely on that philanthropy?
Sure. When you're talking about donors, especially donors who give a significant amount of money, more than like $100, more than that sort of thing, they start thinking about a tax and estate planning, right? And they have to think about how to use their money wisely, how to set it up in, especially if it's a lot of money, how to set it up where it has stability for organizations that they want to support over time. And there's a lot of tools in the toolbox for that. And I won't bore everybody with it, but there's things like trusts, there's LLCs, there's lots of things that you can do to have where your desire to support an organization can even outlive you. You can even go on from in a long time. There's donor advised funds, lots of options. And so this is a common tool, a common estate planning tool, or a common financial planning tool that is used by people to organize how they give money. This allows for some protections and that sort of thing. Now, once you start having beneficial owners and they're having to say, well, what are you doing with this money? Like who owns the LLC, all that sort of thing, then it's starting to get reported of and what these activities do and who they're supporting. And that's sort of the back doorway of getting at some donor disclosure. It doesn't seem like it at first because 501c3 charities are exempt, but what ends up happening in the practical world, the way financial tools are used, is there's a real danger of having donor disclosure through this law.
Thanks so much, Tyler. I want, as we wrap up, to look a little bit towards the future. So many of our listeners are non-lawyers, and you guys have alluded to a lot of important First Amendment protections, first freedoms. Can you just educate us a little bit about your framework in approaching legislation like the CTA? There are a lot of fundamental issues here that would apply to any kind of privacy-related, coercive type disclosure regulations. So, for those of us who aren't focusing on these issues day in and day out, can you set forth some general principles and standards that we can keep in mind whether we're looking at the current or future versions of the CTA or other legislation in these areas? And Brian, maybe you can start us off, and then Tyler, maybe you can provide the NTUF perspective.
Absolutely. So here at People United for Privacy Foundation, we are an advocacy group that focuses on protecting the right to privately donate to nonprofit organizations. So we view any issue as a lens of how does this impact nonprofit giving? How does it protect the right for people to privately associate with each other? So that's the lens we came in with this law. And once again, initially when we reviewed the law, we saw, oh, okay, 501c3s, charities, trusts are exempt. No problem. Wrap it up. Let's go home. But once again, you dig a little bit deeper and you find out that, as Tyler mentioned, that it's in around to disclosure. It's a backdoor that has significant implications for nonprofit organizations. And we're like, okay, well, this is bad. This is problematic. But it's also, you've heard me say and discuss this issue within the framework of just the government databasing and warehousing all this massive trove of information. And for us, that's an immediate red flag because we have seen this issue before play out, and it's problematic every time. Whenever the government starts a dragnet collection of information, it's a powder keg. It's vulnerable to all types of nefarious actors who want to use that information and weaponize that information against their opponents. So between those two issues, just between the massive collection of information, the violation of privacy, and the impact to nonprofit giving, um, yeah, this law was very problematic, and we're hoping that future iterations of it and rulemaking will help solve those issues. But I fear that just the core of it and the core of its existence is probably uh, unsalvageable.
So for non-lawyers looking at this, I think anytime you hear the government or somebody in the Congress or whatever say, well, we need to collect all this data so we can find the bad guys. Remember that they're saying that they're assuming that everybody's a bad guy until you can prove otherwise. What they want to do is they want to make it easy and just collect massive amounts of data on everybody in the hope of finding a few bad. And that is not a good enough reason, because if you show me what you spend your money on, you show me what your priorities are, you show me what you care about, you show me in a lot of cases your politics or your religion or a million other things. And so the government in America has no right, and I would argue just naturally the government should not ever collect massive amounts of data on what people do every day. You can't assume criminality. You can't assume that people are always up to no good. You need to not just collect on everybody. If there is a situation where there's bad actors, because bad things happen, there's criminals out there, then the law enforcement already has the tools it needs. It has warrants. It has uh, surveillance techniques and stuff that have already been approved in law for a long time, even since the founding, that would allow for investigation of particularly bad actions. But that does not give the government the right to collect data on everybody. But the government, as a general trend in the last 20 or 30 years, has been collecting more and more data. FinCEN exists to be a clearinghouse. That's its whole purpose, is to be a clearinghouse of financial data. So as you go forward, as they say, well, we need to find the bad people. Remember, they're assuming that everybody is a bad person unless you can prove your innocence, and that's not how America works. That's not how our Constitution works. And our first freedoms say that we have the right to privately associate because it protects the right to free speech, and it also protects the right to religion, especially for those who are on the outs, particularly those who are not, accepted in the majority viewpoint of the culture at the time.
Great. Now, I wanted to wrap up with a final thought, and I think both of you may have kind of answered this in your last answer, but we'll make it nice and clear. So you get one last opportunity to weigh in on the CTA as a whole. So, okay. If you control the legislative process entirely, right, you can determine the fate single-handedly of the CTA, right? Can the CTA be narrowed, fixed in a way that satisfies your concerns and accomplishes its goals, right? Can we properly cabin and protect the information collected? Can we narrowly target crime without being a wide dragnet? So you can answer this in a sentence if you like, but can the CTA be successfully reformed in a way that works and addresses your concerns, or does it have to go? So maybe Tyler, you go first.
The CTA needs to go. We've been focusing on the First Amendment issues on this podcast, but there's also federalism issues. This is the core role of the states. The federal government just should not be involved in this in any way, shape, or form. And all of the fixes, by the time you do all of the fixes necessary, it would be a dead letter anyway.
And yeah, I'll echo that. And I'll add that there's already a bill in Congress to repeal it altogether. I think it was Congressman Warren Davidson and Harriet Hagerman, if I remember correctly, who introduced the bill. So finish the job, Congress. There's already some appetite there for it. Yeah, it has to go.
This was a perfect closing note. I think I learned a lot. I took some notes here. I'm like, okay, here's our framework. We are on the lookout for laws that are over inclusive, preempted, unwarranted, chilling, and have inadequate data security protection. So if you or a loved one has been just kidding. I think this is a really helpful framework for thinking about the CTA moving forward, any future regulations around privacy, financial privacy, donor privacy, and ultimately freedom of speech and freedom of association. So, Tyler and Brian, thank you so much for joining us and helping our listeners and our team understand this important issue. And thank you to all our listeners for joining us for another episode of the Napa Legal Podcast. As always, if you enjoy our content, we would appreciate if you would like the podcast and subscribe to our channel. We hope you'll join us next week as we continue to highlight and discuss some of the most important legal issues affecting religious liberty and the work of faith-based nonprofit organizations.
Tyler and Brian, thank you so much for taking the time. And thank you to our listeners. Thanks for joining us, and God bless you all.